A landmark case may have rendered the notwithstanding clause of the Charter, by which the government can violate our constitutional rights, powerless and moot, at least in cases where the use of the clause is found to be unconstitutional. This is highly significant in light of the January decision this year by Federal Court Justice Richard Mosley, which found Trudeau's use of the Emergency Act during the Freedom Convoy to be an unjustifiable violation of our Charter rights. Section 33 of the Charter of Rights and Freedoms, known as the Notwithstanding Clause, empowers both the federal parliament and provincial legislatures to enact legislation that may override specific charter rights and freedoms. This clause permits parliament and provincial legislatures to opt out of court rulings pertaining to Section 2, Fundamental Freedoms, Section 7 to 15, Legal Rights, and Section 15, Equality Rights of the Charter. To invoke the Notwithstanding Clause, governments must explicitly declare within the legislation that it operates, quote, notwithstanding particular charter rights. The application of the Notwithstanding Clause is constrained, or at least it's supposed to be. It cannot be used to supersede democratic rights, mobility rights, or language rights as enshrined in the Charter, as it was in the travel ban, which prevented unvaccinated Canadians from boarding an airplane in our own country. The courts went so far in protecting this illegal act that in the travel ban case brought before the courts last year by Brian Peckford, the sole surviving author of the Charter, and the Justice Centre for Constitutional Freedoms, the court dismissed the case, declaring it moot, as the travel ban was no longer in effect. This is tantamount to declaring an assault case moot because the assault is no longer in progress. But this decision brings new hope that may pull the teeth of tyrannical governments who use the clause to freely violate our charter rights. The Supreme Court judges in the case, Canada Attorney General versus Power, which was released just last Friday, found that the government was entitled to only a limited immunity from charter damages for the enactment of unconstitutional legislation. The Court of Appeal dismissed the government's appeal of the decision, agreeing with the motion judge that the government does not enjoy absolute immunity in exercising its legislative powers. According to the court decision, by shielding the government from liability in even the most egregious circumstances, absolute immunity would subvert the principles that demand government accountability. While the court decision does not specifically reference Section 33, the Notwithstanding Clause, it does say explicitly that while absolute immunity is needed for the preparation, drafting, and enactment of legislation, this immunity does not apply in the determination of the validity of legislation once it is enacted or the legality of acts taken pursuant to the legislation. What all this means is that we may be about to see a slew of successful lawsuits against Trudeau's government for damages caused by the use of the Emergency Act.